we can get this moving forward now. I'm going to go through an outline of some of the remedies that are available in California and some of the tools that are available to help you collect. And unfortunately, today's kind of difficult economic environment for the work that you guys do on jobs. I have before you an outline of the basic tools that you have available in California to help you collect. On private works, you have mechanics liens. You also have stop payment notices that I'll go through in more detail. And on some private works, you actually have payment bonds. They're discretionary. They're not mandatory. And then on public works, which I'm sure a lot of you are doing nowadays, if you have a contract direct with the governmental entity, you have a government contract claim, which has hoops which in of itself you have to follow. You also have stop payment notice remedies to the owner, and there's also the payment bond remedy if you're the subcontractor to assure payment. And then for those of you working on federal jobs, you also have the Miller Act payment bond, which is a surety obligation to get you paid for work done on federal acts. So that's a brief overview of the tools you have, and then I'm going to go through some of the ways to help you utilize those tools when you're working on construction projects. There's a number of things you need to think about when you decide to work on a job. One of the things I point out is bidding. That's something you can use that's going to help you collect at the end of the day. So I'm going to go through some tools that you can use in bidding. Contracts obviously are very important, the language you have in the contracts to give you protection. I'm going to go through the preliminary lien notice that you need to give to make sure you give the prelim right, which preserves those stop notice, mechanics lien, and bond remedies. And like I tell all my clients, if you don't do it right on the front side, then I can't help you as much on the back side. The preliminary lien notice is very important, and even the bond saving provision that California's had for a number of years on payment bonds has been modified, and I'll go through that so you can understand that for certain circumstances, if you don't give the preliminary lien notice, the only claim you're going to have left is a contract claim. And then on private works, you have mechanics liens, which obviously put a lien against the real property. You have stop payment notices on public projects and private projects, payment bonds, prompt payment penalties that you can try and use as leverage to get paid when people are slow paying, to try and threaten those to get your payments. And then I'm going to go through the statutory releases to make sure you do those correctly, because again, if you don't do the statutory releases correctly, you may be waiving some of these rights to mechanics lien, stop notice, or payment bond if you do the releases incorrectly. So I'm trying to walk you through those tools as well to make sure you do that correctly, so when you try to collect, you haven't waived any of those rights once you get to that point. Obviously, the first thing that most of you guys do when you look at a job is you're bidding a job. And what I always say to my clients is, make sure you really want the job. You know, you need to look at the ability to pay of the owner or the general contractor you're working with. The pay-if-paid case that I worked on a number of years ago, Clark versus Safeco, the owner in that case didn't have the best financing in place, and when the general contractor realized that, he tried to pass that risk onto the subcontractor. So do what you can do to find out if there is stable financing for the project. And those of you who are in ASA are familiar with, or hopefully will become familiar with, the private-public partnerships where they take what are generally public works jobs, but they become a quasi-public job. There may not be payment bond protection on these P3s. So it's something you want to make sure there's financing in place that you get paid at the end of the day when you're doing the work. Other projects that you're looking at, you need to, again, you want to make sure that the general contractor you're working with, you want to work with them. Is there sufficient capital or credit to perform the job at the end of the day? Skilled is the type of work that you're trained to do. There's been a lot of people that have done private works and they try to get into the public work sector, and they're not really trained as far as dealing with prevailing wages and things like that. And it's something to consider when you look at a public job if you've been doing private works. Am I skilled enough to know how to do this? And the other thing to consider as well when you're bidding work is, how's that going to impact my bonding capacity? A lot of times you do have to plan ahead and say, if I get this job, I may not be able to bid these other jobs. So make sure it's a good job that you feel confident in, because it's going to impact your bonding capacity long-term in doing work. And obviously the bottom line for all of you, is it profitable? You want to look at the job and make sure it's profitable, and I want to give you some tools to try and give you some protection. If you do it, that you can get paid and you thought you were going to realize a profit, at the end of the day you actually do realize a profit. Some of the things to consider when you are bidding: make sure the scope is clearly defined. Most contractors are really good at the scope part of it, but you want to make sure that your exclusions are very clear for what you're doing, and then obviously certain specifications if you're working only on certain areas, that you identify the certain specs that you're going to be performing under, and not have something that's overly broad and they're trying to add things to your scope that you didn't bid, and then you're having fights over change orders at the end of the day. Again, in your bid, the price should be clear, payment, retention terms should all be clear in it. One of the things that I recommend doing is the conditions of bid proposal, and if you go to asaonline.com, that's one of the tools that they have available to give you some ideas to put in the conditions for bid proposal. And the other thing I highly recommend is limit the time that the bid will remain open, that you make it limited to a certain amount of time, because you're subject to price changes and other things that may occur that you really have no control over. So if you've got a bid and you don't have a timeline on it, I have clients who get contacted 6 months later, and if they didn't have a limit on it, then it becomes a gray area as whether that bid is still valid, because there wasn't a definite timeline when the bid was submitted for the project. Some other things for you to consider, at least at the first stage, is what clause are critical to you, or you often hear the terminology in a lot of seminars, the murder clauses. The payment terms, the limit effective pay when paid clauses. Even though pay if paid is against public policy in California, you frequently see contracts that say, I'll pay you when I get paid, and then they'll go on to define that when to say, that's going to be after I've had the opportunity to sue the owner, pursue any appeals, and 6 months to collect on the action. So you may be saying, well, they can't pay me if they don't get paid, but if the contract defines when is 5 or 6 years from now under those circumstances, that's something for you to be aware of. And even when you're bidding the job, at the initial bid stage, you're putting payment within 30 days, 60 days to give you some protection in the bid process when you're doing it. Another thing to look out for, retention. Try to limit to 5% or the same amount being withheld from the owner and the prime contractor. Now in California, they have they do have 5% retention on the public works, but the thing you have to look out for is a lot of these jobs are deeming them substantially complex. So even though you may think you're going to get that, there's a process where they can have it deemed substantially complex. So try to get that in your bid documents. You're saying no more than 5% retention withheld. Another clause that you'll see in a lot of the contracts you get refer to termination for convenience. And if you remembered, I talked about a couple minutes ago about how a job may impact your bonding capacity. For instance, you may get a job and it's a very good job, and maybe it's even 10% of your workload, but if there's a clause in there that says they have the right to terminate it for no reason at any time, that would prevent you from getting your lost profit on the job. So that's something to be very much on the lookout for. I've often said that at some point, if I get the right case, I would try to challenge that as being an illusory contract. It's not a real contract because they could terminate it at any time. But if you have a $100,000 or $200,000 job, that's not litigation you want to get in, and you don't want to forego bidding 5 jobs because you have this one big contract, and then a month into the job they terminate it, and it takes you another 5 or 6 months to get a job to replace it, and you can't get your lost profit. So it's something very much to look out for, is a termination for convenience clause. And again, it's something I would recommend when you're bidding the job, that termination for cause only, no termination for convenience. Another thing to look out for, especially in private jobs, is look out for a no damage for delay clause or disruption clause. And you try to also get in there a price escalation. Say prices go above 5 or 10% during your course of work, that you want the ability, if material prices go up, that you have the right to request a price escalation. And something for you to look out, a lot of times you'll see on public jobs when you're doing them, they'll require you to order the materials up front. So you need to be very much aware when you're looking at that, because that could be something that impacts a claim for price escalation after the fact, because if the contract requires you to order the materials up front and store them on site or store them in some way, you need to be aware of that. And then if you are aware of it and you have a trade that it's just not convenient to do that, you're an electrical contractor and you can't order all that wiring, you need to put the general contractor or construction manager on notice that that's not feasible on this job, that do you want me to order it? If you do, then you have to give me some place to store it. Another huge thing, obviously, is an attorney fee clause, where in the event of litigation, the prevailing party is entitled to attorney's fees. What happens a lot of times is you get to the end of the job and the general contractor will come back to you and say, well, it's going to cost you 30% of this to go after it anyway, so they're going to try and leverage a discount out of you if you don't have a clause that provides for the prevailing party entitled to attorney's fees. So again, that's something I highly recommend you put in the contract, and it'll help you collecting for it at the end of the day, and it'll give you leverage where they won't be trying to discount you right out of the gate when you're trying to collect on a contract. And then obviously in the contract, the scope and exclusions that you have in your bid, make sure they're reincorporated into the contract itself. And what I highly recommend you do is reincorporate the bid by reference and include language in the event of an inconsistency between the bid and the contract if the bid supersedes and controls. Because that way your scope of work will control and the conditions that you put in your bid will control, and it gives you, again, more leverage to try and collect at the end of the day once you are in that contract and you're trying to collect on the backside of the job. To go through some of the prerequisites that you need for a bond, stop notice, or mechanics lien claims, you have the 20-day rule where you're supposed to, even under the Business Professions Code, to give a preliminary notice within 20 days of beginning work, advising that you're actually doing work on the job. And obviously, hopefully most of you know, certified mail return receipt requested is the preferred method. The California statute provides some other ways to do it, but I'll tell you that's the easiest, most economical, and the safest way to do it. And then when you get those return green cards, or if they're not delivered, the returned envelope, hold on to those, because that's the best way to prove that you actually complied with the 20-day rule. If for some reason you didn't give the preliminary notice required within the 20 days, give it as soon as you realize it, because it'll still reach back 20 days from the date you give it. So it's not fatal for not giving it, but it gives you as much protection as possible the sooner you give it. And if you ever have a contractor say, I don't want you to give a prelim, the excuse you can give them is the Business Professions Code requires me, if I do a job more than $500, I have to give a preliminary notice under the license laws, Business and Professions Code. So don't let someone give you an excuse, please don't prelim this job. Just tell them I have to stay in compliance with the Business and Professions Code. And as far as the parties that are required to give that on a private works, anyone who's not in direct privity of contract with the owner and on the lender, that's the only way they know you exist. By serving the preliminary notice on the owner and the lender, they know you have a mechanics lien claim. And then if you're a direct contractor, you've got to serve it on the lender, because that's the only way the lender is going to know who the general contractor is that it exists. And then on public works, technically if you're in privity with the direct contractor, also known as the general contractor, you wouldn't have to give a preliminary notice, but I recommend you do it. It puts them on notice that you exist, and it gives you more protection to collect at the end of the day. So again, it's something I highly, highly recommend. And just remember, certified mail, return receipt requested. And then under the new code sections, it's California Code 8200 for private works and 9300 for public works. Again, serve it within 20 days of when you start work. Even if you serve it late, it'll relate back to 20 days, but don't let someone talk you into not serving it. That is the main tool to enforce your mechanics lien, stop payment notice, and bond rights is timely service of that preliminary notice.
Scott?
Who do you serve? Yes.
We have someone that has a question.
Sure.
I'm going to Barbara Parkman. I am going to unmute now. Barbara, go ahead. Hello? Barbara? Okay, we must be having technical difficulties. She is unmuted. Barbara, if you will type your question. There she is, Barbara. It seems that she keeps coming in and out. Okay, I'm going to request for you to type your question, and then I will ask it of Scott. Sorry about the interruption.
Not a problem. As far as service of preliminary notice, who do you serve it on? Obviously the owner or the reputed owner. Find out what information you can to verify that information. And however you get that information, save that. I recently had a trial where the owner information was disputed. My client had an email with an address that technically had the wrong address typed on there, but since it had the information they were giving, we were able to establish a trial that they did in fact serve it on the reputed owner and able to recover a $250,000 mechanics lien based on that. And then obviously the lender, that's the only way you're going to have a claim on a stop notice. You have to include the lender. And under the circumstances where construction may have began before the loan was actually given, then you would have priority over that lender as well in foreclosure of the mechanics lien, and then also on the prime or direct contractor on the project. And then if you're working on landlord-tenant, it's also necessary to serve the tenant and the landlord because they both have ownership interest in the property, so you need to serve the prelim on both of those. And the thing you need to look out for as well that will absolve a landlord, look out for notice of non-responsibility posted at the project and recorded, which will mean you won't have a mechanics lien interest against the real property. You would only have a mechanics lien against the leasehold interest, which is of really little to no value unless it's the world's greatest lease. And then the purpose of the notice of non-responsibility, obviously, is to protect the owner who didn't contract for the work. Typically, a landlord who's renting out space and whatever changes are being made, they're not going to benefit from those, and that's the whole purpose of the notice of non-responsibility. But that gets back to what I talked about earlier in the seminar, is you need to make sure there's financing in place and the tenant can pay for it at the end of the day, because if they can't afford it and there's not financing in place, then you're going to have problems collecting it at the end of the day because the person you have a contract with may not be able to pay for the work that's being done. Another important part of the preliminary notice is to make sure you get the estimate correct. You'll hear some people say that they just plug a number. I put $10,000, $15,000 on every single one, or they have some other methodology but isn't based on that job itself. You need to have an estimate that can be some way of calculating, because at the end of the day, you need to be able to testify that you had some methodology that you used in order to form that preliminary notice and the amount you put on there. If you don't put a good faith estimate and you just plug a number, the court can say that the preliminary notice was not valid. You have to have some way, again, that you calculate it. Don't plug a number. At the end of the day, even if you get the estimate wrong, that's fine, or if they increase the work by 5 times even, that's not the important part. It's that when you did the original estimate, it's based on some methodology used, or you were given a number by the person you were contracting with, and that's how you came up with the preliminary notice. A lot of people ask me if they need to serve a second one, if they increase the scope. What I tell you, if you're doing the same type of work and they increase the scope, no, you don't need to give another preliminary notice. The key is just to make sure you get the estimate done correctly. Here is a copy of the current California preliminary notice. Hopefully all of you threw away your old ones on July 1st. One of the things you really need to look for, if you see where the red arrows are at, that notice to property owner, that language has to be exactly what that says in there. That's language that's required by the statute. So you need to make sure the language in your preliminary notice matches the language in the notice to property owner, because that is specific language required by the statute that gives notice to the owner. The other area you see with the red arrow is the relationship of claimant to the parties. That's something that's relatively new in the statute that you have to say if you're a subcontractor, material supplier, general contractor, whatever your title is, and then who you contracted with. And then the third arrow on there, I can't emphasize this enough, you use a good faith estimate, and you need to put a number in there as far as what you estimate the work's going to be. That way you're putting them on notice. My potential claim is this. Again, yes, it can increase 5 times over, but at least you told them you exist and there was a methodology used. So those are the keys to getting the preliminary notice done correctly, so you in fact will have mechanics lien, stop payment notice, or bond claim at the end of the job. This form's extremely important. It's like the ticket to everything else for the rest of your remedies. The other part of the preliminary notice, it's now required as a proof of service. And most of the forms, hopefully you see out there, even if you go on our website, you need to make sure that the proof of service refers to the type of notice given, in this case the preliminary notice, the date and place and manner of service and showing how it was given, again, hopefully certified mail return receipt requested, and the name and address to and capacity, if you know it, of the person that you're giving it to. And again, if by mailing, I highly recommend certified mail or registered mail for proof of payment. And I can tell you again, that trial I had recently where there was a question whether they served it on the correct address. Another issue in that case was they hadn't done a preliminary notice under the, a proof of service. Under the old statute, a proof of service was not required, and at the time of mailing, it had to be done in order to prove it up. So that client actually did a proof of service after the fact because that employee was still with them. But if you have a circumstance nowadays, if you don't serve the proof of service with the preliminary notice, the court can say that you didn't give a valid preliminary notice. So you have to have the proof of service as part of it and save that proof of service along with the green cards, because that's how you're going to show that you actually gave the notice of it. So I know you're mailing out the prelim. Make sure you keep a copy of the prelim and a copy of the preliminary the proof of service for the preliminary notice, because the proof of service is now just as important as the preliminary notice itself, because it's a prerequisite to showing that you gave a preliminary notice in the first place. You can't do it after the fact now. You have to serve it when you serve the preliminary notice. And again, here's a copy of the declaration. The big thing is hopefully you're checking first class registered or certified mail and fill out the information of the entities that you're sending it to. And like I said earlier, the key is the addresses that you're plugging in here. It's really important that you keep the information where you got it from, because if someone later says you didn't serve it on the right construction lender at the right address or the right owner or public entity at the right address, if you're able to save how you got that information, that's going to go a long way that you had substantial compliance with the statute because you served it on the entities and the addresses you were given, and that will protect you at the end of the day to say, you know what, I did what I was told, and you'll have a valid claim because you have proof that you served it on the entities and persons that you were told of. The next one you'll hear about most commonly on private works are mechanics liens. What a mechanics lien is, it's an involuntary lien upon real property, just like a trust deed has against someone's house. It actually is a lien against the real property. It's important to remember it's recorded in the county where the property is located. Some people don't realize that, but the only way it works is you've got to record the mechanics lien with the county recorder, or you're physically doing the work. The other thing that's extremely important is once you record it, you only have 90 days to file a lawsuit to quote-unquote perfect it. Some people have the misinterpretation, once I file mechanics lien, it stays against the property forever. Unfortunately, that's not what happens. After the 91st day, it technically has no impact on the real property itself. So you need to make sure you actually file the foreclosure action before that 91st day, or the mechanics lien going to be no force in effect. And if you leave it out there too long, the owner actually can file an expungement action and force it to be removed, and you would be responsible for the attorney's fees after they give you notice if you fail to remove it. And then the other thing to be aware of, if there is a senior lien holder, such as a loan or something, that's the most common thing you'll see, then you could be wiped out if the loan was given prior to starting construction and the lender forecloses, then you could be wiped out by it. But fortunately, under California law, you do have the stop notice, so you would still have your stop payment notice against those loan proceeds as well. So you would have an alternative to the mechanics lien when in fact you are wiped out. As far as the mechanics lien, when do we record? If there's no notice of completion, you've got to record it within 90 days of the actual completion of the project as a whole. Not specifically your work, but the project as a whole. If there is a notice of completion, if you're a direct contractor, 60 days. If you're a subcontractor, which I assume most of you are, you've got to record the mechanics lien within 30 days of a notice of completion. Now, sometimes there are premature notices of completion, and I would always tell my clients, if you're unsure that notice is valid, go ahead and record it, because you may be able to show that the notice of completion was recorded prematurely. But make that determination before you actually file the foreclosure action, because you could have some problems in that regard. But by far the most important thing is record it within 90 days of actual completion or 30 days of a notice of completion. Who's entitled to mechanics liens? There's some question about this. Obviously, licensed contractors of every tier, prime and sub. Material suppliers to a contractor or a subcontractor. If you're a supplier to a supplier, you don't have lien and bond rights. But under the Ayers decision that I have mentioned at the bottom, in that case, there was what was technically a supplier to a supplier, but they were providing specially manufactured item, in this case doors, pursuant to the plans and specs, and the court said they in fact did have lien rights. So when in doubt, I would still say serve a preliminary notice, and even if you're a material supplier to a material supplier, I would still say serve a preliminary notice, because at least you're letting them know you're out there, and they're going to make sure you get paid prior to paying people upstream from you. So even though you may not have lien rights, I would still recommend serving the preliminary notice to give you some protection. Laborers obviously have lien rights. Site improvers and, under the current law, design professionals such as architects and engineers also have mechanics lien rights. So these are all people that do in fact have rights to mechanics liens, And you all will share equally. It doesn't matter that you're the grader at the beginning or the landscaper at the end. Once the mechanics liens are recorded, they all have equal priority, and you would share pro rata once the property is foreclosed to whatever amount you have in your mechanics lien. Who's not entitled? Obviously, unlicensed contractors or subcontractors, material suppliers to material suppliers. But again, I would say still go ahead and give them the preliminary notice just to protect yourself. Equipment broker to equipment broker, which is like a material supplier to a material supplier, or if you're just providing like off-site administrative service as opposed to on-site management. So those are all things to consider. But again, I would recommend giving them the preliminary notice, and at least they know that you exist. The mechanics lien form I put on the screen for you. The big thing for you to remember is make sure you're using the current mechanics lien and not the one that was in effect prior to the amendment of the statute July 1st, 2012. The big way you can always tell, if you look at the section number on the second line, it's going to be an 8,000 number. Anything that starts with a 3,000 number is going to be the old statute. So the reason I put it on there is just to give you the heads up to know that's the code number you need to look for under the new statute. Anything with an 8,000 number, to know whether you've got a new lien or an old lien, and make sure you use the correct one, because if you use the wrong lien, it's going to be of no force in effect. And again, the notice provision that's required, make sure your lien has this language. You can see it refers to Civil Code 8416. This is language that's required under the statute, so make sure your lien has this language. Similar to the preliminary notice, the mechanics lien also requires a proof of service and requires the lien to be served on the owner. And the county recorder's office actually is not supposed to accept the mechanics lien for recording unless, in fact, you do record it with the proof of service. So again, it's required as a prerequisite to have a valid lien, and most county recorders should not accept it without the proof of service. And again, if you try to foreclose on the lien and you're in trial, you're not going to prevail unless you actually have a valid proof of service showing the owner that you gave them notice of the lien. So it's absolutely required. Make sure you do it. Obviously, you can use this form to make sure you're doing it correctly, but you have to have a proof of service. As far as mechanics lien enforcement, the one thing is not as much a worry for contractors, but whatever attorney that you hire, and make sure they know construction law. And when you file the lawsuit to enforce the mechanics lien, the statute requires you to record what's called a notice of lis pendens. And just to give you some understanding about it, like I said before, you've got to file the lawsuit within 90 days. And once you file and record a notice of lis pendens, that lets anyone know who's looking at the record title. They'll see the mechanics lien, and if they don't see a lis pendens within 90 days, then they're going to think, well, that mechanics lien is no force in effect. So the notice of lis pendens puts any prospective purchasers on notice that the mechanics lien does exist and it's been enforced. So if they were to purchase it, they purchase it subject to the lien that you have in the property. Again, if you fail to file within 90 days after the mechanics lien, it's unenforceable. It's of no force in effect. And like I mentioned before, the owner is entitled to attorney's fees to expunge the lien if you leave it against the property without a lawsuit after 90 days. The owner has to give you a notice and opportunity to remove it, but I'm going to tell you, if you went past 90 days and you didn't remove it, if you get that letter, you need to remove it, or they can recover from you the actual attorney's fees they incur to have that lien expunged. And the other thing, that it does not run with the land if you fail to record it within 90 days. That's the old perception people have. Well, if I don't record, it's just going to sit there forever. No, it sits there for 90 days. And on the 91st day, it's of no force in effect. So you need to make sure you file that enforcement action within 90 days. Otherwise, it's not going to do you any good whatsoever. The other tool that's available under the statutes referred to as a partial release of mechanics lien. Sometimes you'll have a lien, they're going to make a partial payment, and they're going to ask you to release the whole lien, and I would say I would recommend you don't do that, because you create an ambiguity, because you're not doing new work now if you try to record a second lien. The safest thing to do is record a partial release of mechanics lien, and that partial release of mechanics lien will set forth the amount you've been paid and the amount you're still owed. So you can record that, hopefully satisfy the owner, okay, I'm acknowledging the payment I got, but I can't release the whole thing because I haven't been paid in full, and I'm not doing any new work to record a new mechanics lien. So the safest thing to do is the partial release of mechanics lien, which shows the property is partially released but not completely released under the mechanics lien. The other thing that you'll see in regards to mechanics liens is the mechanics lien release bond. It replaces the mechanics lien against the real property itself, and it has a longer timeline where you have 90 days from the notice of the mechanics lien to pursue it. What happens is if they get a mechanics lien release bond, they're supposed to serve it on you, certified mail, return receipt requested, and once you get that, you have 6 months to file suit. So you do have some time, and some people have the misconception, well, now I don't have the property securing my lien anymore. Actually, in some ways, this gives you easier protection to collect on because this is going to be a bonding company that's going to pay you money if you get a judgment against the bond. So instead of having to foreclose on the property and have a sale of the real property, you would actually have a bond in place that sits there and says it has this amount of money and you can be able to get a monetary judgment and have them pay you, as opposed to when you get a judgment against the mechanics lien, you have to go through the second hoop of actually selling the property. But the big thing to remember, again, it's not going to sit there forever. You must file suit within 6 months after given notice of mailing, not when you actually receive it, but when they put it in the mail. That's very, very important, again, because if you get to 6 months and 1 day, there's no oops, I forgot, or a second chance. If you miss that deadline, it's gone, and that remedy is no longer available. So you have to file suit within 6 months of the mailing of that notice of mechanics lien release bond. The other tool that you have on both public and private works is the stop payment notice, and it's a statutory remedy designed to reach unexpended construction funds in the owner's or lender's hands, and is available both on private and public works. The big difference between the two: on private, it must be bonded or there's no obligation for the lender to withhold funds. So that's the big thing. If you're doing it on private works, you need to make sure you get it bonded, and then that'll require the lender to hold the money. And the advantage in that case as well is there's an entitlement to attorney's fees. If you file a lawsuit on a bonded stop notice, you have an entitlement to attorney fees at the end of the day. On public, there is no bond required, so you'll see that all the time on public works, giving the notice to the owner to withhold the funds because you've not been paid and you want them to withhold the funds that you're still owed on the project. The stop payment notice, what it does, it stops the money. Some people, especially before the statute was renamed for clarity, when it used to just be called the stop notice instead of the stop payment notice, people used to think, well, it stopped the project. No, the project's still ongoing. It just stops the flow of money from the owner or the lender. And it's served on the owner or the lender. And again, it must be bonded or served on commercial lender to mandate the withholding of funds. You can serve it, but if it's not bonded on a private job, the lender doesn't have to hold it, and there's no harm, no foul if they don't withhold the funds. And if you serve it on the owner, say there's no lender, but there's an owner, you can bond it as well if you just serve it on an owner that's self-financing it. The advantage of doing that is it does give you the right to attorney's fees in the event that you bond it even on owner-held funds. Obviously, the disadvantage is you've got to pay the bond premium for it, but that's something to consider. If you don't have an attorney's fee clause in your contract, then you may want to consider going ahead and bonding it to give you some leverage to make sure you can collect at the end of the day. Again, public projects, it's not bonded, and you simply serve it on the owner of the project. On stop notice, who's entitled to it? It's basically the same people as the mechanics lien: contractors, subcontractors, material suppliers. It's the same set of people that you have on the mechanics lien side, but it just sets forth who, in fact, is entitled to it, but you have to be a contractor. You can't be a supplier to a supplier or a broker to a broker, so you've got the same limitations if you're too far downstream that you're not going to have the right to a stop notice. Stop payment notice, as far as what it has to contain within itself, it must have a general description of the work that you provided, an estimate of the value of the work that you provided, and the amount claimed is only the amount you provided through the date of the notice itself. Now, a lot of times people will say, well, I'm not done yet. I want to serve it in the middle of the job. I don't always recommend that unless you're just afraid they're going to run out of money, because if you do it in the middle of the job, what you're going to end up doing is having to amend that stop notice while you're still working for each subsequent progress payment that you send in. So if you send a stop payment notice, you can't do it for work you haven't done yet. It's only going to be for the work you've actually done and completed. Now, I'll say you can do it for change orders that you've completed. They may not have been approved, but you're saying you're entitled to them. By all means, you have the right to put them on there and make sure you have everything on there that you've done through that point in time. Because if you have change orders that you've done but they're not approved and you serve a stop notice for the lower amount, then you're going to create some ambiguity later in time when they say, well, you did this, you had claimed it, but you didn't have it in the stop notice. So it's safest to include everything you've done, including the change orders that aren't approved because you've done the work at that point in time. So once you've done it, you have the right to claim it because you've in fact done the work. As far as who you have to serve it on, maybe serve it on the same person since entitled to mechanics liens. Again, direct contractor needs to serve it on the lender. If you're a direct contractor, that's the only way the lender is going to know you exist. And subcontractors and material suppliers can serve it on the owner, public entity, or lender. And then again, on private work, it's only required to be withheld if, in fact, you bond it. I can't tell you enough times. People, if you're used to doing public works and you're doing a private work and you're saying, well, I just serve a stop notice, I'm private, you need to remember that you have to, in fact, bond it on private works to require them to withhold the funds. And then a claimant wishing to receive a return notice of the time for enforcement of the stop payment notice must pay the public entity $10 at the time of giving the stop payment notice. So it's one of those things where you can say, if you pay an extra $10, they're supposed to, in fact, let you know when the time runs to enforce it. I would tell you not to rely on that, but it may give you some protection in regards to trying to find out when it's done, but don't rely as that your only source of information. Keep following up with the public entity and the general contractor to find out when the job is actually done, or if you have some agency that you can contact to find out when a notice of completion is recorded. Again, the information that's required on the stop payment notice, similar to the mechanics lien, identify the project owner, the direct contractor, the lender, and then if you notice in the middle there, a description of the services you're providing. That's required to be placed on there as well. And the other thing that's very important is the verification on the bottom. You need to make sure you sign in both places, because if you don't verify the information is correct, then you're not going to have a valid stop notice because you haven't verified the information is true and correct. Again, the other thing you've got to have, just like the mechanics lien, just like preliminary notice, you have to have the proof of service declaration. So you need to make sure you fill this out correctly and fill in all the boxes to say, in fact, this is what I did, I served it, and here's the proof of service. If you don't have the proof of service, you're going to have the same problem that you have a mechanics lien, a preliminary notice. You're not going to have a valid stop notice because you can't prove that you actually served it with the proof of service, which is one of the prerequisites of having a valid stop notice. The stop payment notice, it actually has some benefits over the mechanics lien, and especially on private works, if you can afford bonding, it really has some huge benefits. Obviously, it's not wiped out by foreclosure, because in most construction projects, the construction loan is recorded prior to construction beginning. So if the lender forecloses, it would wipe out your mechanics lien, but you would still have the right to the proceeds held by the lender under a stop payment notice. The other advantage is the stop payment notice has immediate effect. As soon as you serve it, the lender, the owner, are going to withhold funds. There's going to be an immediate impact that flow of cash is stopped to the general contractor. The other advantage is it's silent. It's not part of the public record. A mechanics lien is recorded, and there's many credit agencies that will be able to tell everyone on your job that so-and-so has recorded a mechanics lien, and there's problems with payment on this job, so everyone else then starts serving mechanics liens. If you have a stop payment notice, no one knows about it, and a lot of times, quote-unquote, the squeaky wheel gets the grease, so they want to take care of you before everyone finds out there may be a problem out there. So it has that huge effect of saying, it stops the flow of money. We want to take care of this person before anyone finds out there may be some payment problems out there. So it really does have some nice effects. The other thing on private works, it has the availability of attorney's fees. So if you have to bond it and you have to file suit on it, you have the right to recover as attorney's fees, which are not recoverable on a mechanics lien action. And the other great thing about a stop notice versus a mechanics lien, the mechanics lien, you have to foreclose it within 90 days. The stop notice doesn't work that same way. You don't have to foreclose it or enforce it within 90 days of serving it. It actually runs to the end of the project. And the easiest way to explain it is you would have to enforce a stop notice within 120 days of notice completion or 180 days of actual completion. And what that actually refers back to is you have to enforce it within the time that you had to record mechanics liens and enforce those. So it runs all the way to the last possible day that you could have enforced a mechanics lien that you have the right to have a stop notice. So you literally can have a stop notice as the grader on the job sitting there for a year and a half protecting your payment rights but not having to incur the attorney's fees to enforce it after 90 days like you do on a mechanics lien. So it definitely has some real benefits at the end of the day because it doesn't have the short timelines that you have on mechanics liens. As far as when to do the stop payment notice, again, if there's no notice of completion, you must serve the stop payment notice within 90 days. If there is a notice of completion, you must serve the stop payment notice within 60 days of notice of completion if you're a direct contractor. If you're a subcontractor, then you must serve the notice of completion within 30 days. But that's why you have, if there's notice of completion, serve the stop notice within 30 days. But again, the beauty of it is filing lawsuit. The lawsuit is 90 days after the last day to file a lawsuit, or 180 days after actual completion, or 120 days after notice of completion. It's not tied to the date of the stop notice itself. It's tied to the project as a whole. So you can sit on it for a long time if you need to in order to avoid the expense of attorney's fees and while you're ongoing negotiating on what needs to be done. The release of a stop notice, it can be released at any time. It must be in writing, obviously, and identify whether it's a reduction or a complete release. The key to the stop notice, mechanics lien is a gray area. I'm recording the second one, but the stop notice, you don't have that issue. It bars a future claim to enforce a stop notice as there's no further obligation by the owner or lender to withhold funds. I just had this past week. I had a client contact me and say, hey, the general contractor wants me to release funds so they can get the money from the owner. Can't I just record a second stop notice? No, because you're not doing any new work. You've got to look at that from the perspective of the owner. They see a release of stop notice, say for $100,000. They now believe you, in fact, have been paid. And that's why the statute doesn't let you record a second stop notice for exactly the same funds. Now, if you do a stop notice and you release it and then you do more work, okay, then you can go and proceed for that, for the additional work you do after that date. But you can't do it for exactly the same work. And then the release of stop notice doesn't release other payment rights, like a payment bond or anything like that, unless you're signing the statutory releases that I'll go through later that refer to bond, stop notice, and mechanics liens. But like I said, you can do a subsequent stop notice later if you do more work. So that's the key. If you do additional work, then you, in fact, could do a stop notice for that later work. Again, the release of stop notice form is here for you to see. Just the key for you to look at, again, at the top number, if you see something in the 8,000s for private works or the 9,000s for public works, to make sure you're using the correct forms nowadays. I just want to make sure no one has any of the old forms still in their form files. And then, again, if you get a partial payment, again, like in my client's case, what we were able to work out, they were going to make them a partial payment. So we gave them a partial relief, but not until the payment is actually made. You got to make sure you get the payment and the funds clear before you give them the partial release of the stop notice. So it's an alternative when you're not getting paid in full, and it keeps the rest of the stop notice in place, and it gives you that protection to say, okay, as soon as I get paid, I'll give you a partial release, but I can't release the entire amount. The other remedy you have in California, in addition to stop notice and mechanics liens, obviously, are bond claims. And there's a number of different types of bonds in California. There's contractor's license bonds. It's a very small number, small amount, but it is a bond that you can get recovery against. Bid bonds, if you're bidding a job, obviously they can make claims against your bid bond, or if you have someone bidding to you and they have it bonded, they can make a claim against, you can make a claim against their bid bond. Performance bond, which most of you have to post on public works for making sure you finish the work. And payment bonds is posted by the general contractors to make sure that they in fact pay their subs, or a lot of subcontractors obviously to make sure they pay their subs, and material suppliers. And then there's also mechanics lien release bonds that we talked about, and there's also stop notice release bonds where if they bond around your stop notice, similar to the mechanics lien release bond, instead of sitting and holding the construction money, it'll be a different source of money that's available and you can make a claim on the stop notice release bond similar to the mechanics lien release bond. As far as what a payment bond is, basically it means a bond for good and sufficient sureties that are conditioned for the full payment of claims of claimants. That also means to ensure the benefit that you get paid for the work that you do. I mean, basically that's what they're there for. On private works, they're discretionary, but the pay-if-paid case that we had back in the mid-90s, that actually was recover on a private work payment bond. So don't say you never see them, because actually how the contractor in that case recovered was on the payment bond on the pay-if-paid case. And then on public works, bonds are required for all projects in excess of $25,000. So I always tell someone, if you have a public works job, you know you're going to have a stop notice claim and a bond claim. And the advantage is the public works payment bond claim is going to have the right to attorney's fees as well. As far as who's entitled to a payment bond, basically it's the same people that have the right to mechanics lien and stop payment notices. Anyone who furnished labor, materials, equipment, or material to the job or work of improvement and was not paid the full amount of work. So if you're still owed money and you furnished labor, services, equipment, or material, then you have a right to a payment bond if there's a payment bond in place. Payment bond claims, preliminary notice required for public and private bond claims, and I'm going to show you the claim you can actually send to the bonding company to make a claim on the bond. If a preliminary notice is required, i.e. if you're a material supplier or a sub to a sub on a public works job, you may still claim a bond even if you didn't give it within the 20 days, but you've got to give notice to the surety within 15 days after notice completion or 75 days after actual completion. But under the current law, and I'll go through a little bit later, that doesn't guarantee you get paid if the general contractor's already paid the subcontractor above you. And then notice to the surety and bond principal must comply on the private works with 8100 as far as certified mail, return receipt requested to make sure you served it that way. It gets back to save those green cards, certified mail, return receipt, save those green cards because they're like gold. Payment bond claims, if you're relying on the fact that you didn't give a preliminary notice, then the thing that will keep you from getting paid is if the subcontractor to whom the claimant, you guys, the downstream subcontractor, has been terminated from the project and all progress payments have been made as of the termination date. So if you didn't do the prelim and you're trying to do the bond saving provision, basically if the general contractor can show he's already paid the subcontractor above you, then you're not going to be protected, which gets back to that's why it's so important that you do a preliminary notice timely at the beginning. So I can't emphasize that enough, like I said before. If you don't do the prelim right on the front side, the attorney you go to may not be able to help you on the back side. That's why it's so important that you get those preliminary notices done. As far as the notice to surety, you can use this form. Basically, it's got the surety itself, the bond principal, which will be the general contractor typically that you're working with, and the claimant, and then it has the information that you need to give the surety as far as questions that you need to answer in the notice to the surety. And then again, you need to sign it at the end of the day, and you'll never guess what the next slide is, a proof of service. Under the current statute, you have to have a proof of service because that's how you show, in fact, that you gave the notices that were required by the statute. So it's very, very important that for all the notices that you send, that you do a proof of service for all of them. It becomes important as the notice itself as the proof of service that you sent it. So you need to keep both of those. They're now extremely important under the statute. The other thing that's very, very important that you do as you go along are the statutory releases. I'm sure everyone's familiar with them. You've got the conditional waiver and release upon progress payment, the unconditional waiver and release upon final payment, conditional waiver and release upon final payment, and unconditional waiver and release upon final payment. So, and I noticed I got final payment here twice. So unconditional waiver and release upon progress payment. So you got the conditional and unconditional for progress and conditional and unconditional for final. The caveat I always tell you, don't give a final unconditional until the check is cleared, because once you give that unconditional, remember, it's not for the benefit of the person you're giving the release to. The benefit of the release is for the upstream lender and owner. Those are the people that are relying on that. So if you sign a release that the check is cleared, the check is cleared. and you're releasing your right to record a mechanics lien or stop notice for the amounts you put on those releases. So they become very, very important. The one thing you're not waiving under the statutory releases are contractual rights. But remember, if you're going against the mechanics lien stop notice payment bond, typically whoever you have a contract with probably doesn't have the money to pay you in the first place. But you're not waiving those contractual rights, something at least to consider at the end of the day. But you've got to be very careful on how you complete those releases. Under the new forms, there are some changes that have been made to actually make it a little more clear. The conditional waiver and release on progress payment now has language relating to progress payments not covered by the previous release that's not been paid. In the old days, what would happen is you would have a release and you didn't get paid for, you would say for January you were owed $100, and then you hadn't been paid January, and you get to February and you're owed another $100. Most people would just put $100 for February, even though they were really owed $200, and they would be waiving that previous January amount. Now the releases have a specific place for you to put in how much you're owed for the previous month. If you have some general contractor telling you to put a 0 in there, don't do that because you're waiving the previous month, not until that check clears. And you can tell them when, in fact, I get the payment for the previous month, I'll give you an updated release. And then remember, all forms have a line for identification of who the customer is working with, so that becomes very, very important. As far
Scott,
as the,
Scott, we have a couple questions.
Sure.
The first question is, how do we know when a notice of completion has been filed?
You can, obviously, when you serve the stop notice, that's one way of asking. I know in Southern California and in Northern California, to a certain extent, there's two organizations, BICA, Building Industry Credit Association, and CMA, Construction Managers Association, or Credit Management Association. They both have private services that you can sign up for to find out about it, but none of those are guaranteed. There's no perfect way to get the answer to that. The best way is, again, if you're a member of BICA or CMA, sign up for their services and they can let you know there is some cost to it, or keep track of the job itself to find out what's going on, because there's no foolproof 100% way to find out when there is, in fact, a notice of completion. I wish there was, but there's no perfect way. You said you had a couple questions. Do you have another one besides that?
The next question is that sometimes we don't get the green cards back. The post office is not helpful. It's not helpful in us trying to obtain the actual green card. My understanding is that the printout of it being delivered and signed for from UnitedStatesPostalService.com is not evidence enough. So we have been refiling the pre-lien and resending it to obtain at least a green card return receipt and keep the printout form from the original mailing as backup that we did send it timely, but never got the original green card back. Are there any other options that we have if we don't get the green card receipt back from the post office?
Under the new statute, you would have some protection with the postal printout, but it's still not a guarantee. The green cards are by far the best way to do it. I actually haven't had a client that actually sent it out and didn't get the green cards back. I've had the entire envelope returned, and I've got even the green cards back without them being signed. I've not heard a lot of clients complain that they actually didn't, the whole thing never came back and the green cards was still floating out there. But I don't have a problem with printing it out and trying to reserve it to make sure you get a green card. There's not a problem with doing that the way. Obviously, the owner would be arguing that the second prelim was the only one they really got, and then I would be arguing if at a trial, here's where we sent the first one and the green card was never returned. So it's not a bad idea to try it. If you never do get it back, keep the postal record. The current statute's a little more forgiving than the old statute was, but I hate to say it, the old joke is people get fired from the DMV, go to work for the post office. So there is no perfect way. I mean, if you wanted to spend more and it was a multi-million-dollar job, the statute allowed FedEx or other express mail service, which would make sure you in fact get it back. So if you have a really, really big job that you're really concerned about, that's another way of doing it. It would give you that protection. The statute now actually allows express mail or FedEx, and that's easy to track as well to show you got it. So at least it's an alternative if you've got a really big job and you're really worried about getting the money back. referring to the conditional, were there any other questions by chance?
No, that's it.
Okay. Referring to the conditional releases to make sure you get them right. Again, the language in this is statutory language that's required at the top. Again, you've got to have the name of the claimant, the name of the customer, the job location, and the through date. And the through date becomes very, very important, and I'll go through in a little more detail. But if you have the through date wrong, if you put the wrong date, like say the work is actually for work you completed through the beginning of January, but the date you put in there is the end of February, you've just given up all that work through February as far as the entitlement to a lien in that amount. And then the second one underneath there, where you see the second red arrow, you see the amount of unpaid progress payments. That's very, very important that you, in fact, fill that out for the amounts you haven't been paid, and don't let a general contractor say, no, I don't need to do that, because it's very, very important in the current statute that you do, in fact, put all those unpaid lien amounts. And then same thing for the unconditional. You need, again, most importantly is that you, in fact, been paid and the check is cleared before you fill this out. But again, you're supposed to have the statutory language that's at the top, the information that's there in the middle, and then the amount of the progress payment that you're actually receiving. So you got to make sure that those amounts are right. And then again, the through date is extremely, extremely important that you get the through date done correctly. If you see the waiver and releases sections under the current statute or in the 8,000 sections, and the forms that they don't have a section to identify previous progress payments not made. So if you're signing for a final payment, you need to make sure, in fact, that you've got all the progress payments before you're signing for the final payment. Because I have a lot of people saying, well, I haven't gotten that last progress payment. Can I go ahead and do a final release? No, because you haven't been paid for it. And then the other thing you'll notice in there, there's a place for any disputed extras that are excluded from the release, because a lot of times you're getting a final release and you still have outstanding extras. And again, don't get talked into putting a 0 in there and saying, well, we're still working on those, because if you put a 0 in there, you're waiving all those extras and change orders that you're waiting on that weren't included as part of all of those progress releases. So if you put a 0 on the final release, then you're waiving everything. I mean, that's the problem you have. And again, the conditional final can't be given until you've got all the progress payments, because there's no place to exclude those previous progress draws you haven't gotten. So again, don't put a 0 in there if you have outstanding change orders, and you can't give a final if, in fact, you haven't gotten all those progress payments through that point in time. Again, conditional waiver and final release, you got to have that statutory language at the top, and then the bottom arrow I have there, disputed claims for extras. If you put a 0 in there, you're walking away from all those change orders, because you're not going to have a mechanics lien stop notice of bond right to those claims. They're extremely, extremely important that if you have anything still outstanding, that you put them in there. Same thing on unconditional waiver and release. Make sure the check is cleared before you give it. You got to have that statutory language at the top, and there's any disputed claims for extras, you have to include them in the unconditional final as well. Like I was saying before, the through date is extremely important. The Tesco case was under the old releases, but basically what that case says, if you list a certain date that you've been paid through, you're waiving any claims for any work done before that date. Even if the check doesn't clear as far as if you sign an unconditional, that's why you have to do the conditionals to say it's through that date and you have the amounts correct. So the through date is extremely, extremely important. If you get the through date wrong, like I said before, if you're filling it out in January, then you need to make sure it's for work only through January. If you do it at the end of February and you haven't been paid for the February work, you just have to be clear as far as the work that's covered through that through date, and also including the amounts that you haven't been paid in the previous draws. It's extremely, extremely important that you keep those dates correctly, because what happens a lot of times is you're going to get paid 6 months after the fact, and then you're going to have to take the time to figure out what's actually paid for that work that you're getting the payment for. So when you give them an updated release, that you're only covering through the date that payment's actually paid for, not the date you're actually getting payment, because it's extremely, extremely important. Prompt payment penalties, this is just one of the collection tools that you can try and use to threaten and get payments when people are behind on making payments to you. Obviously, a state agency must pay a prime contractor within 30 days of receipt for request for payment, and then the prime contractor must pay subcontractors and lower tier subcontractors within 7 days of receipt of funds. And I know that typically doesn't happen, but at least gives you some leverage when you find out they haven't been paid, that you can tell them, you know, if you don't pay me, I have the right to 2% per month plus attorney's fees for the failure to make payment. So it's a great leverage tool for you to say, you know what, if I don't get paid, I'm going to hold firm till I get those penalties as well. And then on public works or improvement, retention payment must be paid within 60 days of date of completion. And again, the prime contractor must pay within 7 days of receipt of the owner. Again, if they don't pay you within that time, it gives you great leverage at the end of the day to try and say, hey, I haven't gotten that payment, I need to get that payment, and gives you leverage against them to say, if you don't pay me, I'm asking for 2% per month and attorney's fees if I don't get that payment. Penalties, again, 2% per month plus statutory interest of 10% per annum. So those are, you get 2% penalty plus your 10%. So they add up on top of each other. And then you have the right to attorney's fees and cost. The one thing you'll hear a dispute about is they are allowed to withhold up to 150% of the disputed amount if it's disputed in good faith. And the Martin Brothers case, which has caused consternation among many of us subcontractor attorneys, where they'll try and use your claim for extras and saying, well, we have a dispute as to that, so we're able to withhold that amount as well. But they are able to withhold 150% of any disputed amounts in dispute, basically. So it can be not only that, the amount that you're claiming, but plus an additional 50%, which causes some consternation, but is what the statute allows. But you can still try and threaten them, hey, there is an undisputed amount you owe us, and if you don't pay it, we're going to make prompt payment penalties for those claims and ask for interest and attorney's fees. On federal works, you have the Miller Act, which provides payment of persons supplying labor and material used for the work covered by the prime contract, and it covers all first and second tier subcontractors, and suppliers can make a claim against the payment bond on the Miller Act. And again, that as to federal jobs, what constitutes a first or second tier subcontractor or supplier? A subcontractor or supplier who has a direct contract with the contractor is a first tier subcontractor or supplier that can recover. A subcontractor or supplier in direct privity of contract with the first tier subcontractor is a second tier subcontractor or supplier and can recover. Employees of a second tier subcontractor are not protected. And then subcontractors and suppliers who have no privity of contract with the contractor or first tier supplier cannot recover, basically a supplier to a supplier. So they don't have the same protection. But the Miller Act is the source of protection when you're working on federal jobs. And it states that anything that's in the prosecution of the work is designated in the prime contract. You have the right to make a claim. And unlike a mechanics lien, a Miller Act claimant is not required to prove that the labor was actually used and consumed, but only furnished in the prosecution of the work. So it's a different way of proving it. Basically, you provided it to the job and it was used on the job. You don't have to show it was consumed on the job. So it's a different definition, but as long as you show it was provided to the work of improvement, then you have the right to claim under a Miller Act bond. Time limits, it's basically 90 days from when you finish the work, except when in direct privity of contract with the general contractor, must give notice to the contractor within 90 days of the last labor and materials been furnished. So you have 90 days to let them know that you're doing the work, or on the back side if you're direct privity, 90 days after you last provide work. And the lawsuit must be brought no less than 90 days after the amount becomes due to the claimant, but not later than 1 year after the claimant last performed labor or supplied material to the job site. So on Federal Miller Act, you have a much longer time than you do on mechanics liens. I don't think most of you want to sit around and wait that long, but you do have a longer time period to pursue the Miller Act claim. So it's not the same short time frames that you have on payment bonds and mechanics liens in state court. And then for those of you that are working directly with a governmental entity, you see that a lot on school district jobs where you'll have a CM and 30 different bid packs. You're not going to have a mechanics lien or a payment bond claim. Basically, what you have to do is a government claim, and that's a direct contract with a government entity. Requires a government claim before filing suit against the public entity. So you actually have to do that prior to having any claim against the public entity. I apologize, I had something pop up on my screen. You have a direct contract with a governmental entity. You can't just sue them. I have clients all the time say, I want to sue them for breach of contract. You have to file a claim first. And when you look at your contract, beware of the notice deadlines and requirement to give notice within X days, i.e. 7, 10, sometimes as little as 3 even, of the event giving rise to the claim. And if you don't give them notice, what the public entities are going to claim is that you waived your claim because you didn't give them timely notice of the claim. So it's very important to look at your contract and know the time frame that you have to give notice of the event to give rise to the claim. And then the contract itself will have a claim procedure. So look at the contract documents and understand what the timeline of what you actually have to do to make a claim. Do you make it to the construction manager? Do you make it to the architect? Do you make it to the public entity? What is the procedure to make a claim? And I can't reiterate enough, you can't just file a lawsuit against the government. You have, as a prerequisite, you have to file a claim or it's void. So you can't just sue them. You've got to look at your contract, you've got to see what the claim procedure is, and follow that claim procedure and give them notice timely when in fact those claims come due so you can pursue those claims. It's very, very important that you in fact do that, because if you don't, it's like I said at the beginning, if you don't do it right on the front side, I can't help you on the back side. So if you come to me at the end of the job and you've done this work direct for a school district and you say, hey, I want to sue him because he didn't pay me, you got to make sure you gave him notice the whole time of whatever extra cost or you're claiming that you haven't been paid for. And then the last tool that I talk about when we're talking, it's especially useful on prompt payment, is a public records request. California law provides for public records for most items. And I have a lot of clients that they think the general's been paid, but they're not sure. You can actually make a public records request to the public entity and see when in fact they were done. And I've done that more and more times on behalf of a client, and we're able to show the general contractor that we know you got paid, and we use that as leverage to get paid, or saying, you know what, we're going to file suit for prompt payment penalties. And then it's such a great, great tool. I've used it a number of times. And again, any public job, you simply can make a public records request. You can look online. It'll show you how to do it on the form, or you can retain an attorney to do it. But it's not something that is really, really necessary to retain an attorney. But it'll show you by requesting the records for the job when, in fact, they were paid. Normally what happens is you make the request. The public entity will write back to you and say they'll either make them available or tell you the cost of making the copies. And it's a great tool to get prompt payment penalties when a general contractor hasn't paid you and to find out what's going on the job. So I hope that's been of some benefit to you. Obviously, we've got time for questions if any of you have any questions about some of the things we went through as far as the collection tools in California.
I will now, if anybody has any questions, I will now unmute everybody so you can ask verbal questions if there are any. I have one last question that was asked regarding the forms.
Okay.
The question says, so can we now use other alternate forms of proof of service, for example, FedEx, etc., under the new statute?
You can use, yeah, you can use other methods of serving. You can use FedEx. The only downside of FedEx is the expense, because the key is you've got to maintain the proof that you sent it. But FedEx is expressly allowed under the current statute, as opposed to just certified mail return receipt. You can do it by FedEx. It's just, you know, $15 versus $4. So that's the only difference. But it's definitely allowed under the new statute. But again, you still need the proof of service that you sent it, and then the proof from that express service company, their records that it was actually served.
Okay, I have now unmuted all of the attendees if you would like to ask any verbal questions. All right, well, there seems not to be any more questions. No more questions are popping up on the screen. Oh, there is one more. Let's see. Question says, I am a sub who sends my retention billing with the conditional final within 30 days of my final progress. In most cases, this is before last progress payment is made.
That is a risk.
Am I avoiding my rights? Am I avoiding my rights to the process?
The progress payment, there's definitely an argument to be made that since you haven't gotten that last progress payment, that you are, in fact, when you send the final release with whatever amount you're asking for in that amount, unless you're accumulating the last progress and that last final together. If you haven't accumulated those two, yeah, you are in fact waiving that last progress payment, because you just have to remember the lender is looking at that final request and saying, okay, you're owed $100,000. If you don't have the $50,000 from the previous draw, they're thinking, okay, if they get a check for $100,000, they're paid in full.
Okay. No more questions? All right. Well, thank you so much, Scott.
Thank you.
Really appreciate it. I appreciate your help with this. And again, I apologize for the technical difficulties that we had at the beginning, but hopefully it didn't interrupt the process too much. And we'll see you guys at the next webinar.
Thank you all
for. Have a great afternoon.